Hi class, today we're going to cover Chapter 1, which is the Introduction to Family Law and Practice. It covers a wide range of topics, which will kind of ease you into what to expect for the rest of the semester. By the end of Chapter 1, you should be able to identify the major themes of family law in the 21st century, understand how the practice of family law interacts with other areas of the law, learn the major terminology changes in family law, state the tests used by a court when a family law is challenged as a violation of due process or equal protection. Understand the impact of social media on the practice of family law. List the variety of roles paralegals can have in various family law offices and settings. Identify the dangers of bias in the practice of family law. Understand the dangers of dealing with volatile clients in the practice of family law and how you potentially could be endangered by working in this field. And also know the main legal research sources of family law and where they can be found online and on the shelves of a law library. So just to give you a brief outline of what to expect, hopefully by now you should have read the chapter and this is just a primer for you. We're going to cover family law in the 21st century, terminology, scope of family law, con law, practicing family law in the age of electronic exhibitionism or social media, paralegal roles in family law cases, other family law roles, assessing your own biases, violence in a family law practice, family law sources, and you should be able to go over the sample problem and skills assignment in the book if you're interested in that, which I highly recommend. Major themes in the 21st century. So continuing struggle for equality of the sexes. As recent as 2 centuries ago, the wife was subsumed in the husband. What that means is she had no legal responsibilities or capabilities on her own as a wife. When she got married, her identity was subsumed in the husband. So only the husband could open a bank account, only the husband could enter into contracts. If the wife did want to do anything, she had to receive the consent and permission of the husband. What this also meant was the wife couldn't sue the husband, because what that meant was the husband was suing himself. She could not accuse the husband of rape, because that would mean that the husband was raping himself. So clearly, as recent as 2 centuries ago, wives had very little clout or bargaining power, if you will, in a relationship. More recently, the law has moved away from the unity of the person and shied away from the theory based on male dominance. To a large extent, the law has equalized the legal status of husband and wives. It's important to note, though, that however the law has reflected equality in power between husband and wives, human behavior hasn't exactly caught up to the law just yet. The book gives an example of a 1991 case that demonstrates an agreement between the husband and wife as to all of the permissions that the wife would have to receive from the husband in order to do simple things such as withdrawing money from a bank account. She's not allowed to dispute with him in public on any matter. So this is just an example of how human behavior hasn't necessarily caught up to the law, but we are taking steps forward in terms of equality of the sexes in marriage. One of the biggest examples of that is that of no-fault divorce. California is a no-fault divorce state. So what that means is either spouse can initiate a divorce based on irreconcilable differences. Along with no-fault divorce, we also see commingling of property, and so the division of property would be equal, it would be equitable, not necessarily equal. So for example, in California, if there's any property that's obtained during the divorce, that is shared property between both spouses. It wouldn't only be the sole property of the husband as it was in the past. Another major theme in the 21st century is the increased federalization of family law. So family law in general falls within the purview of state power, as enumerated by the 10th Amendment in the Constitution. However, having said that, we see federalization and U.S. federal law dipping more into the realm of family law. Some major themes where we'll start to see federal law a lot more in family law is in tax, bankruptcy, abortion, paternity, interstate child custody and kidnapping laws, child support collection, which is probably the biggest one, where the federal courts are setting the precedent on processes of how to enforce the payment of child support, and state laws having to follow those procedures. We also see an increase in the contract dimension of family law. So whereas before the marriage was seen as the unit of family law, a lot more younger folks and more recent generations are starting to view the concept of marriage as more of a contract partnership. So this is where we're starting to see the increase of cohabitation agreements and domestic partnership agreements and contracts as opposed to actually getting married. So how can they draft a contract agreement to receive the benefits of a marriage? For example, tax breaks, health benefits, death benefits, life insurance, etc., without having to actually get married. So what does that mean religiously if you, as more people are shying away from the union partnership as a marriage under the eyes of God, and instead looking to contracts to determine the parameters of their relationship? So we'll talk about that a lot more as we get into divorce, and really looking into what marriage means and what it has meant in the past and what it means now in the 21st century. We're also going to be talking about science and family law, particularly the advancements of science in the realm of reproductive health, especially with the increases of folks who are no longer able to have kids, or perhaps don't want to have a child in a relationship and are seeking to be a single parent. How has science and technology affected the realm of family law? Again, this all goes back to the marriage as a unit of the family, marriage as a sole unit of family law, and how has that broken down or alternatively transformed with the increase of science and technology and the increase of contracting as opposed to getting married. We will also talk about the deregulation of sexuality. Again, where the marriage of was a union between a man and a woman with the sole purpose of having children, how has the deregulation of sexuality affected that theme in family law? In Lawrence v. Texas, it decriminalized private sexual behavior between two homosexuals, and we're shying away from the regulation of intimate conduct and leaving that for individuals and partners to decide on their own. These are the 5 major themes that have affected family law in the 21st century and will continue to affect family law moving forward. A major goal more recently in family law was to move away from terminology that encouraged parties to view themselves as winners or losers, and instead focus on an amicable resolution of conflict, particularly when children are involved. So whereas before, terminology would set parties against each other. While the reasons behind these changes could possibly be cosmetic, some words just sound better or make more sense, other reasons could be because they wanted to emphasize responsibilities rather than rights, and downplay an emphasis on morality, and types of language that could encourage and incite anger and fighting as opposed to mediation and reconciliation. So major examples of new family law terminology, whereas before, the breakdown of the marriage was called divorce, it's now called a dissolution. Alimony, or support owed to one spouse, is now called spousal support, which makes sense. Illegitimate child, out-of-wedlock child, or bastard is now called a non-marital child. As you can see, there's less emphasis on blaming the child or negating their existence, but instead simply calling them a non-marital child. Custody, visitation, access to the child, which is still used heavily in the courts, particularly because of precedent and preference, can also be known as a parenting plan, which involves both parents now and suggests that they've planned this together as opposed to being told their rights. Other examples include caregiver as opposed to custodian, Family law and practicing in family law is a unique opportunity to be considered a generalist in a sense because there's so much overlap in the types of cases that you're going to deal with. Some of the major other areas involved in family law include criminal law, contract law, corporate law, bankruptcy law, tort law, civil procedure, and evidence. When I worked for a legal aid, a lot of the issues that I worked with in criminal law, mainly the only issues I worked with involved domestic violence. So while it was criminal law mainly, there was a lot of overlap with family law. And a lot of the issues that I dealt with were restraining orders and child custody orders as a result of that domestic violence. I think it's definitely worth reviewing the different types of law that intersect with the example given on page 6 of your book. I'm going to go over the example briefly and just go over a few questions that should run through your mind as issue spotters when reading this example. Assume that you are a paralegal working for Karen Smith, an attorney in your state. One of the clients of the office is Susan Miller, who lives out of state. The attorney receives the following email message from Miss Miller. Karen Smith, I am leaving the state in a week to live with my mother in your state. She will help me move everything so that we can start a new life. I must see you as soon as I arrive. Yesterday, my husband called from his business. He threatened me and the 3 children. I will bring the twins with me. I don't know where my oldest boy is. He is probably with his father getting into more trouble. Signed, Susan Miller, the client. At this point, you should be developing a checklist that are potentially relevant to the case of Miss Miller, otherwise called issue spotting. So in criminal law, you would ask, has Mr. Miller committed a crime? What kinds of threats did he make? Did he assault his wife and children? And has domestic violence been committed? For divorce and separation law, what does Miss Miller want? Does Miss Miller want to know what her husband wants to do? Does Miss Miller have grounds for a divorce? Child custody law. If Miss Miller does not want a divorce, annulment, or legal separation, how can she obtain custody of the children? Support law. Is Mr. Miller supporting his wife, or is she supporting him? Are the children covered under Mr. Miller's health insurance policy? Is Miss Miller covered? Under contract law. While she is living apart from her husband, can Miss Miller enter into contracts with merchants for the purchase of food, clothing, furniture, medical care, prescriptions, and make him pay for it? Can she use his credit? For real property. What rights does Miss Miller have in Mr. Miller's separate property? What is Mr. Miller's income? Can his wages be garnished? Under corporate law. What kind of business does Mr. Miller have? Is it a corporation? What are the assets and liabilities of his business? For bankruptcy law, is there a danger that Mr. Miller or his business might go into bankruptcy? If so, how would this affect Miss Miller's rights to support and to her share of the marital property? Tort law. Can one spouse sue another in tort? Has Mr. Miller committed any torts against Miss Miller? For example, assault, fraud, conversion, or intentional infliction of emotional distress? Civil procedure. How can service of process be made? If Miss Miller sues and obtains a judgment in this state, can it be enforced in another state? And we'll do one more. Tax law. Have Mr. Miller and his wife filed joint tax returns in the past? Are any refunds due or money owed on past returns? This can go on and on into estate law, Social Security, professional responsibility. So as you can see from a very brief client interaction, your mind would be running through issue spotting, and you'll notice that at least one or more other areas of law will intersect with your practice of family law. With the increased federalization and changes implemented in family law, it's important to understand how these changes have come about by way of the Constitution. So we're just going to do a quick primer on constitutional law. Hopefully This isn't your first introduction to due process and equal protection, but if it is, it's okay. This will serve you in your practice as a paralegal. We'll be looking at the two major federal challenges based on the U.S. Constitution, which are due process and equal protection. So due process is outlined by the Fourth Amendment of the Constitution, which states that no state shall deprive any person of life, liberty, or property without due process of law. Now, due process of law is broken down into two processes: procedural due process, which is the method, and substantive due process, which is the content. Procedural due process requires that the procedures used by the government must be fair. Remember, at stake here are a person's life, liberty, and property. Before any of those fundamental rights are taken away, the procedures and the method must be examined and must be proven to be fair. Now, substantive due process requires that the government must avoid arbitrary and capricious actions. This is the content, the meat and potatoes, that ultimately could result in the deprivation of a person's life, liberty, or property. This is a constitutional requirement that the government avoid capricious actions that would deprive someone of their life, liberty, or property, regardless of how fair the government is in the procedures that lead to the actions. So while procedural due process outlines the methods, the substantive due process piece is really focusing on whether or not there is a fundamental right at play or at issue, or a non-fundamental right. If there is a fundamental right at issue, it is judged by the process or the test of strict scrutiny. So for example, the right to marry is a fundamental right, whereas the right to adopt a child is a non-fundamental right and would only be judged by rational basis. Because there are two tiers of rights, fundamental rights and non-fundamental rights, the analysis of whether a restriction violates substantive due process faces a two-tiered analysis. If there is a fundamental right involved, then it must pass the test of strict scrutiny. What does strict scrutiny mean? It means that the restriction has to be narrowly tailored to serve a compelling state interest. It's a high standard to meet. The restriction must be narrowly tailored to serve a compelling state interest. However, if the restriction is a non-fundamental right, for example, the right to adopt, then it only has to pass a broader and easier to meet test, or of rational basis, where the restriction must only be reasonably related to a legitimate state purpose. I would highly encourage you to look at the Exhibit 1.1 on page 13 of your text for a breakdown and a list of examples. Other examples of fundamental rights that require strict scrutiny test are the right to marry, right of couples to use contraceptives, right to direct the education and upbringing of one's children, right to an abortion without undue burden, and other non-family law examples include the right to vote and the right to interstate travel. Non-fundamental rights, such as the right to adopt, also include the right of adults to engage in homosexual conduct in private, the rights of grandparents to have a relationship with their grandkids, and other non-family law examples include the right to use a public park and the right to buy a boat. So the main takeaway of understanding substantive due process is the analysis of whether it's a fundamental right or a non-fundamental right, and whether strict scrutiny applies or simply rational basis test. This also carries over into equal protection of the law. So equal protection looks at classifications of people It is the requirement, the constitutional requirement, that the government treat one group the same as it treats another group in like circumstances. If two groups are similarly situated, the government must treat them the same. So keep in mind, this doesn't mean that the facts have to be exactly the same, they just have to be similarly situated. So in determining which test applies under equal protection of the law, you first have to determine what class of people we're referring to. There are three classes of people: fundamental rights, suspect class, quasi-suspect class, and other classes. So technically 4 rights. We've gone over examples of fundamental rights. What about a suspect class? This would be an issue involving race, national origin, or alienage. Immigration, for example. Quasi-suspect involves the issue of gender or a child's legitimacy, so a non-marital child. The biggest con law issue we see in the quasi-suspects class is any case involving gender questions. Any other class would require a rational basis. So if it doesn't involve immigration, if it doesn't involve gender or the illegitimate child, it would fall into the other class of rational basis. An example of a strict scrutiny test would apply to a fundamental right, such as a statute allowing same-race couples to marry but not mixed-race couples. At this point, since a fundamental right is involved, which is a right that is specifically guaranteed in the U.S. Constitution, is implicit in the concept of ordered liberty, or is deeply rooted in the nation's history and tradition, would trigger strict scrutiny. This means that this classification or statute, which allows same-race couples but not mixed-race couples to marry, would have to be reviewed. Is it narrowly tailored to serve a compelling state interest? Also phrased as necessary to serve a compelling state interest. No, it was found to have not served any compelling or necessary state interest, and so therefore mixed-race couples were allowed to marry. An example of a classification triggering intermediate scrutiny would be a statute that allows women to receive spousal support but not men. The test is whether or not the classification is substantially related to serve an important state interest. There wasn't found to be one, where men would be not allowed to receive spousal support, but only women. That was struck down as well. Here, the quasi-suspect class involved gender, which was men and wives in a marital relationship. Finally, the classification that triggers rational basis, which is minimal security, any rational relation, is the broadest and easiest test to meet. The classification must be reasonably related to a legitimate state purpose. This would be any discrimination that does not involve a fundamental right, a suspect class, or a quasi-class. So while the 10th Amendment does give states the power to outline the laws and rules in family law generally, state constitutions must comply with federal state constitutional law. So the best way to look at this is to think of the federal constitution as setting the bar, but not the ceiling. So long as a state adheres to the federal constitution, it can still set higher standards. So if it wants to impose stricter rules than that outlined by the federal constitution, it can. So again, the federal constitution sets the bar, but not the ceiling, and states must follow that and can exceed the strict rules of the federal constitution if they choose to. We're now transitioning into the impacts of social media evidence in family law cases. E-discovery is a discovery of data found in emails, spreadsheets, database, and other digital formats. Also, including anything that's posted online. So, online data, including Facebook, Instagram, Twitter, dating sites. Even in one case, they found that evidence from a video game was introduced in a family law case to demonstrate that a woman was playing World of Warcraft during a time in which an incident happened. While such evidence is not always verifiable or admissible in court, if you've taken evidence, you'll know why. Hearsay exceptions. But attorneys have found that they can sometimes gain bargaining leverage by simply suggesting that the evidence exists. So evidence of financial resources, evidence of affairs, evidence of bigamy, evidence pertaining to child custody, evidence pertaining to domestic violence have all been obtained through social media methods. So for example, participation in a dating site has been evidence of an affair. Pictures of someone buying a new car or going on a lavish vacation could be used as evidence of financial resources. Comments made on a new boyfriend or girlfriend's picture or suggestive comments could be evidence of bigamy. Evidence pertaining to child custody, if somebody states that they don't smoke or they don't drink and therefore they're providing a safe and healthy environment for the child, could be proven wrong if there's evidence of them on Facebook or Instagram of smoking marijuana or getting drunk and going to bars. Also, evidence pertaining to domestic violence. They could even look at comments. If there's any foul language, that could also be considered relevant evidence pertaining to domestic violence. The rule of thumb is to not post anything at all, to advise your clients to stay off social media, to not speak ill of their partners or not speak on the divorce or custody issues whatsoever. There are some instances of people trying to delete their evidence, or I'm calling it evidence already, but their social media page, which ultimately is evidence. And so some courts have required that Facebook and social media sites turn over deleted pages as forms of evidence in e-discovery. So rule of thumb, be very careful on what you post on social media. It's better to not post it if in doubt. We're now transitioning into the potential job opportunities as a paralegal in a family law setting. In a traditional law office, as a paralegal in family law, you could work all the way from the interviewing of new clients to drafting the settlement stage. So long as you're supervised by an attorney, the possibilities are endless in terms of the scope of work you could do. In government office, you could choose to work for a child support enforcement agency, which would be a lot of fact-finding, determining assets, breaking down the assets between both parties, and determining child support orders. Freelance work, you could choose to work for yourself and help various attorneys on a case-by-case basis, as opposed to working for one attorney or one firm. If you choose not to work under the supervision of an attorney, you could work for the general public. So a guest speaker I had in one of my other classes was a People's Choice, who is based in Ventura. They work as legal document assistants and help people from the public fill out their forms. So they provide services for straightforward divorces as bundles, and they help the public fill out those forms. While they can't do any advising since they're not supervised by an attorney, that is an opportunity if you want to work for yourself and also work for the public in your role as a paralegal. Keep in mind that most folks who end up becoming freelancers have decades or many years of experience working under the purview of a supervisor to learn the ropes and understand the various forms and procedures before going to work for themselves. But that is an option. You could also do volunteer work as a court-appointed special advocate. You don't even need to be a paralegal to do this. You could do this right now as a student or in the future. I attended a few trainings through the court-appointed special advocates, which is basically a support system for a child in the foster care system or anybody going through or a minor going through an abuse or neglect case. So you would act as a facilitator. You would review that child's files and help in determining the best placement for the child based on their best interest. I would highly recommend considering becoming a CASA if you have the additional time, or if you're more interested in seeing how the system works and also making a difference as an advocate without having to practice law or even be a paralegal for that matter. Regardless of what setting you decide to work in as a family law paralegal, you will have to understand and be aware of your biases. And this applies to any field of law that you work in. So a bias is a prejudice for or against something or someone, a predisposition, inclination, or tendency to think or to act in a certain way. It's a danger of prejudgment. Family law especially will trigger your biases, whether you are aware of them or not. The best practice is to be aware of your biases so that you can actively work to dispel them. However, if your bias is so large, the best thing that you could potentially do is speak to your supervisor and see if there's a way to work around that case if it triggers too much of your biases. For example, if you yourself have been a victim of domestic violence and you're given a domestic violence case that has similar facts to your own personal life, perhaps this could cloud your judgment. And what we're looking at is whether or not your bias is so strong that it'll prevent you from giving 100% to the client and ultimately negatively impact their case, whether you realize it or not. So maybe speak with your supervisor or reach out to other paralegals, of course, your peers, while not breaching the confidentiality of the client, just speaking generally about the situation to see if you could seek advice on how to deal with your bias if your supervisor is unable to reassign you. Something you can do is to think about your past and present contacts with people who have irritated you in the most. Make a specific list of what bothered you about these people. Suppose that you're working in a law office where a client did one of those things on your list. Can you handle such a case? In the relationships among a husband, wife, and child, many things could be done that could be wrong, illegal, immoral, according to your own personal system and values. Make a list of the 5 things that could be done by a husband, wife, or child to another family member that would be most offensive to your sense of values. Assume that a client in the office where you work has done one of these things and is being challenged in court by someone because of it. Your office is defending the client against this challenge. What difficulties do you see for yourself in being able to assist the client? So being aware of your biases will help you draw the line between expressing these feelings and reacting so judgmentally that you negatively impact the case and the client that you're working on. So again, alternatives are to reach out to your supervisor, maybe join the Paralegal Association, so you could seek out peers who may have who have experience dealing with similar cases, and could have advice on how to dispel your biases and work through them so as to negatively affect your case. It is important to know that we all have biases, we all do, and the more you know about them, the better you are in dealing with them. Violence. So we should all be aware of the reality that volatile emotions often exist within families undergoing disintegration. I myself have had to receive a temporary restraining order against a client because of the imminent harm that they had threatened to me as well as other people on the staff that I was working on. Individuals who perceive themselves as victims are sometimes capable of lashing out against anyone involved in what they irrationally feel is an unresponsive legal system. Caution is the order of the day. You should have an action plan outlined with your supervisor if it's just you two in a small firm, or if it's a larger firm, hopefully it's outlined in your handbook. If there isn't, you should have a serious conversation with your supervisor about this on what you plan to do if there is an extremely volatile client, or they may not seem volatile in the beginning, but you should constantly be aware of any changes in their behavior, in their language to suggest that you're in harm or in danger. At the end of the day, this is your job, and you don't want to risk your life because of it. So to have a plan in place and to be aware is what you should be of in order to protect yourself and also any other clients involved. Finally, we're moving on to family law sources. Because there's so much law and so much of it changes, especially in family law, no one's expected to know every single law all the time. But it is important to know which sources you will be using most of the time. So by now you should have taken paralegal fundamentals, and you'll know that primary sources include constitutions, statutes, court opinions, court rules, and administrative regulations. Secondary sources are also extremely helpful, particularly in issues that you haven't dealt with before, because they give various interpretations and methods. Google Scholar is another excellent source when you're searching for family law court opinions. So what you want to do is you want to go to www.scholar.google.com and select legal documents if you're looking for case law, or select articles if you want other literature on family law. There are other free sources of online opinions. There's findlaw.com and jucia.com. I've also used openjurist.org or findacase.com. Just keep in mind that when you are using free websites, or if you just use the general broad Google search, that you are aware of who's posting these cases and make sure that it's a complete case before you try to cite anything. So of course, if it's a free site, you don't know who's managing that website. You should also be aware of the other family law sources for California. Family Law Code, major one. You'll want to look at, I would highly recommend looking at the Superior Court website, which I have included the link for. Just go ahead and browse through the different forms just to get a sense of the types of uniform forms that you'll be using if you haven't already been exposed to them. There will only be 2 written assignments for this class. Otherwise, please make sure you have completed the discussion thread if you haven't already. And that concludes Chapter 1. Talk to you next week. Thank you.